Are we on now, Zach? Okay. Welcome. I'm Judy Cheney, member of the foundation board. Albert is here, and Frank is here, also members of the board, and also Marcia, one of our newer members, resident Ann. So yeah, I don't know if people know that she's now a member of the foundation board. So you have two residents in the building, which are on the foundation, so you can always reach out to them if you need help with any item. But welcome, appreciate you coming again. This is our third and last part of our little speaker series that Foundation put on, trying to educate all of us as far as taxes, wills, and whatnot. And August is National Make a Will Month. We were told that back in February, so we thought this would be an appropriate time to kind of go through some of that information. So we have two young guys up here, gentlemen, Tanvir and Sean. They were both here the other two times. We have a new young man, Jake. He is the legal man, I guess. They're all legal, but he has the legal advice for us. So he's going to say something about himself. I don't know much other than his name is Jake. So welcome. Hope you get some helpful information.
Thanks, Judy. Cool. Thanks, Judy. Yeah. So as you said, I'm Sean. This is Tanvir. So we're financial advisors at Heritage Wealth Advisors, and we're excited for today because, as promised, we brought Jake Judd, who's an estate planning consultant with eLegacy, which is the estate planning firm that we partner with. So wanted to give a quick introduction about that partnership. The reason that we've spent so much time investing as financial advisors with the estate planning firm is because oftentimes we see kind of a gap in the industry. So a financial advisor or an estate planning attorney may work kind of in their own silo. They might not collaborate as much with the financial advisor, with the attorney, even though they're giving advice on similar topics. So a lot of times attorneys provide advice such as establishing a revocable trust or a living trust or how to title your accounts, but that plan does not get implemented because of that lack of coordination between those two individuals. So what we'll do differently is we'll do a forward-looking tax projection every year, and we'll use the tools at the disposal of the estate planning attorneys as well as the tools that we have as financial advisors to do those forward-looking tax projections. It may be advice such as titling your accounts, how to list beneficiaries on your retirement accounts, whether or not to set up a trust, and ultimately what we see is better outcomes and plans actually being implemented with the families and individuals that we work with. So, Jake, and pass on to you.
All righty. So, my name is Jake Judd. I'm an estate planning consultant with eLegacy Law. eLegacy Law is the very first of its kind virtual nationwide estate planning firm. Because we're nationwide, we know all the rules topics. We actually started right here in Seattle, Washington, partnering with Heritage Wealth Advisors. We were kind of really it was Heritage, had this brainchild of collaborative care because there's always been that disconnect between attorneys and financial advisors. Attorneys like to be the smartest one in the room. I don't know if there are any attorneys here today, but that tend to be the kind of trajectory when we're working together. So we wanted to break that down and go ahead and have eLegacy Law be collaborative. So that's a little bit about what we do. Just a bit about me. I do live in Coeur d'Alene, Idaho. Came out here just for this trip, visit you guys here today. So I do have two kids, and I always say I'm not the cobbler whose kids don't have shoes. My family has an estate plan. We have a will, we have a trust, we have powers of attorney, and I'm in my early 20s. So that just goes to show you it's never too early and it's never too late to have an estate plan. So kind of the components of a healthy plan. You got your financial plan, you got your retirement plan, you got your estate plan. How do they all kind of go together? How do they all work together? Each different part has got its own role to play. Your estate plan is not easily defined. An estate plan could be a handwritten napkin. It could be a revocable trust. It could be a will. It could be powers of attorney. It is all encompassing of all these different topics, and I'm going to delve into those a little bit more today. So, why is estate planning important? A well-designed plan will protect you It will provide for your family, and it will promote a family unity. Most times when we're looking at estate planning, there are one or two main goals that we have, and it's all client dependent. It depends on what your goals are. Not every one person has the same goal. For me, my primary goal was ensuring that my young kids were protected. If they are inheriting hundreds of thousands or even millions of dollars, fingers crossed, I want to make sure that that money is being spent with the right intention. That was my objective with estate planning. For you, it might be different. It might be, I don't want my kids to fight. I want, a game plan put in place. Everybody gets an equal portion. It's split. Could be, we live in Washington here. Washington has estate taxes. Do we want to avoid the estate tax? Whatever that looks like, that's what we want to sit down and figure out in drafting a well-designed estate plan. Healthy tip number 1 for having an estate plan. Who should have a plan? Anybody have an idea? Everyone! Good job. Class is awake. Planning motivators. 60% of Americans have no plan in place. What causes someone to seek out an estate planner? Most of the time, it is life events. For me, a birth of a child. But other clients, they had a family member pass away. They saw how terrible that experience was, and they wanted to make it not terrible. Moves, careers, big trips, or purchases. Or Tanvir and Sean hounding you, get your estate plan done, because that is an important part of your financial picture. Or just because. Every now and then we'll have those clients that none of those events happen, but they're like, hey, I'm that active individual that wants to get something done. Healthy tip. Why doesn't everyone have an estate plan? Procrastination being the biggest factor. It is not fun to talk about estate planning. I can attest to that, as I do it all day long, every day. I try to keep it light. I do try to throw in some jokes. One joke I threw in during my personal estate planning with my wife was I elected to get cremated. You could do burial, you can do cremation, whatever you prefer. But I told her it's my one and last chance to have a smoking hot body, so I'm going to do that way. Nothing's going to happen to me attitude. That's usually my age, where we think we're invincible. Nothing's going to ever happen to me. I've got tens of years to be looking at that. But there are two certainties in life. Life is death and taxes. And in Washington, we have a plethora of taxes in addition to that. And that's where a good estate plan comes into play. It's uncomfortable to talk about it, especially if we're talking about dividing up our assets. Who gets what? How do they get it? Are we restricting it? Do we have a black sheep in the family? My own personal, my parents, at the ripe age of 18, told me that I would be in charge of the estate. I have 4 older brothers, so that was a bit of a shock to me, seeing as how my oldest brother is 10 years older than me. And I have the benefit of having an addict in the family. So in addition to that, I get to do drug tests for him when we're administering the estate and check in with his sponsor. So having these rules and everything put into place, my parents know that the money is not going to be spent frivolously. It's going to be with the intent that they wanted. But in addition to that, it was not a comfortable topic to broach. And then lack of concern being that last one. A couple of the fundamentals of a good estate plan is, the first and foremost, most people think of the will, your will or trust. They are pretty much right and around the same wheelhouse. Think of a will as, these are the guidelines. Here are my kind of wishes and intents of what I would like to happen with my estate. Your revocable trust, on the other hand, is hard set rules. This is what's going to happen. The main difference being that a will goes through probate, and a probate is contestable and changeable. A revocable living trust, you sat down with an attorney, you adhered to state law, you adhered to federal law. Now that's set in stone. Whatever you had written down at that time, it is revocable during your lifetime, but after you've passed away, it is now irrevocable and it can no longer be changed at that point in time. So that's the one most people think of, is that will. Powers of attorney, there are three main points I always drive home about POAs. The first is that they are not all powerful. You do get to pick and choose what powers you give into who. If you meet with a good attorney, then you can, not always. But powers of attorney, you can pick and choose. One main power I always tell folks to consider not giving to one of their beneficiaries is the power to change your will or trust. Nobody should be able to change what your trust says or your will says other than you when you're in a state that you know what you're doing. Second main point I always make about POAs is that they can be written one of two ways. They can either be written immediately. When you sign that document, whoever you appointed can go to the bank and say they're you and open up a checking account, pull a credit card, get a car loan. Whatever powers you gave them to do, they'd be able to do that immediately. I found it very beneficial to do that for my wife because I like to delegate. And there are a lot of things that I don't like to do that would require me to be there. And so with this immediate power of attorney, I was actually able to start delegating some of those tasks to my wife. Third and final point about POAs is that they do have an expiration date. When I pass away, there's nobody to work on the behalf of anymore. That power of attorney is now null and void. So those are the three main points. Not all powerful. They can be immediate or springing. Springing, I didn't elaborate on this, meaning that they only activate after you've been deemed incapacitated. Could be through a traumatic car accident, could be Alzheimer's, dementia, fill in the blank of what incapacity is. But that's the only time that that one would be activated. Medical directives, these are a lot of times the palliative care, hospice care, tubes, ventilators, respirators, CPR, do not resuscitate. Whatever your intents and wishes are, I always say don't put that on a loved one to decide. It's already hard enough to talk about, and now we're going to go ahead and put that on them to discuss. It's far more advantageous to you and your family to go ahead and already make that decision yourself for whatever you want. Powers of attorney, I went through that a little bit already. How they work, that is a little bit more into the lines of which one we are looking at. There are two different types of powers of attorney. There is a healthcare power of attorney for healthcare decisions. This type of power of attorney can only be written under a springing clause, meaning that nobody can make healthcare decisions for you during your lifetime until you're deemed incapacitated. The general power of attorney is the one that can be written immediate or springing. General power of attorney, it's general. It could be legal decisions, it could be financial decisions, it could be, who's taking care of my dog, who's taking care of my cat, whatever that looks like, that's the general power of attorney. And when can you use them? You can use them with the healthcare power of attorney. You need 2 written provider notices saying, yes, I deem this patient incapacitated at this time. Alternatively, if your general power of attorney was also a springing clause, that would be needed as well. Incapacity. Life is unpredictable. If you should ever become mentally or physically incapacitated, an estate plan will outline your wishes regarding who will make financial and medical decisions on your behalf. Now, one important piece to note is an estate plan should not be patched together. You should not start with a trust or a will and then do powers of attorney later on. You want those documents to mesh and coincide. A lot of times when we have a trust entity, we will take assets from your individual name and we'll fund it to your trust name. When we do that, your trust needs to allow your power of attorney to activate and be able to access those trust-held assets. Because if we don't leave those clauses in there, then that would not be applicable at that time. So they should be drafted at the same time. And then obviously we can update and change as situations evolve. General power of attorney allows you to select someone to make decisions for you rather than a court. This is the most important bit in all of estate planning. If you do not make these decisions today, you are leaving that in a court's hands, regardless of who it is. It could be a spouse, it could be a son, a daughter, it doesn't matter. If we do not make those elections today in a legal document, then the court will ultimately get to be the one that decides. So that is very imperative. If you're writing down notes, highlight that. Healthcare power of attorney. This allows you to choose someone to make important healthcare decisions on your behalf. So previously I talked about a healthcare directive, those end-of-life decisions. Your healthcare power of attorney is doing everything else in between. It could be an elective surgery, it could be dental care, it could be optometry, whatever it is. All of that in between, that is what your healthcare power of attorney is deciding. And again, these are only during a time where you have been deemed incapacitated, cannot make decisions on your own. Will or trust, what are they? How do they work? Who are they for? For me and my firm, I'll start with that bottom one. Who are they for? I am 9 times out of 10 recommending a revocable living trust in the state of Washington. For one, probate is not fun to begin with. For two, it is even more so the case in Washington state. Every state has different rules and procedures. Because we are a nationwide firm, I can strongly say Washington is not a great state for probate. There are 2 triggers for probate in the state of Washington. One is if your assets that you have either individually or jointly, if you're married, accumulate to more than $100,000. That's one trigger. So if you don't hit the other trigger, it doesn't matter. The second trigger is if your assets are less than $100,000, but you own any real property, boom, there's probate. Real estate is a trigger universally in all 50 states. The only major difference is that dollar amount. So for example, the next nearest state that's of a significant lesser value is Utah. If you lived in Utah, your assets could be no more than $20,000. But for the average, we're right around $75,000 to $100,000 cumulative. How do they work? As I mentioned before, a will, it's guidelines. It's not set in stone. Probate is contestable, probate is changeable. Your estate would hire an attorney to represent you in a probate case where we sit down and we read your will, we read Washington guidelines and we read federal guidelines, and we basically adhere to that and allow your assets to be distributed as you intended. The part that is contestable is anybody can contest an estate. It does not matter if they have a legitimate claim to your estate. It could be your third nephew's niece's cousin, and they could say, oh, well, I gave them $100,000 way back when, and they never paid me back. That could be a legitimate claim to an estate. Even if it is not a legitimate claim, what it would do is create a lot of estate expenses on behalf of your estate. So I never like probate, especially contested probates. That will take the timeline in Washington state. It's roughly 9 months to 12 months before these assets are even distributed after probate, and turns that into a 2-year process. And a huge heartache on everybody else who is going through that process. Probate, if you have a will versus no will, it doesn't matter. You're going through probate with both of those options. The only major difference is if you have no will, you're filing under what's called intestacy, meaning you did not make those decisions. Guess who gets to decide? The court. We don't want that. We want to at least have a will plan that says, here's who I want representing me, here's where I want my assets going. At the bare minimum, we want at least that, even if it's not a revocable living trust. A will with administering property after the fact, as I mentioned, it's a little nuanced, but when we're going through probate, we have to go through a process where we obtain what's called letters testamentary. Letters testamentary is basically our permission slip from the court saying, yes, whatever expenses need to be paid, whatever assets need to be compiled, this is where you can go ahead and start it. Now, once we have letters testamentary, we're in a waiting period with notice to creditors. This is where we have to wait the mandatory statutes of 6 months before we can actually start administering any assets. So during that time, that's where we're paying funeral costs, medical bills, any expenses that were left over after we've passed away. During that time, that's where we're paying it, and anybody in that 6-month time frame can come forward as a creditor, legitimate or not, and we would have to potentially pay that estate. However, once all of that's done and we're now through the probate process, this is now where our executor, who we've nominated to represent our estate, can go ahead and start administering assets, whether it be through a will or a trust. A trust administration, on the other hand, is all we need is a death certificate, and we can administer assets just like that. The death certificate shows that whoever was the owner of that trust before has now passed away, and whoever is secondary now steps into those shoes and can read your will, your trust, and your intents for going forward with that. Probate is a court-administrated process, is lengthy, time-consuming, costly, not private. Washington probate limit, $100,000 cumulative. Not private. This means that your will be recorded at the public recorder's office. I have one client in particular, I love her very much, but one of her favorite pastime activities is to go look up her friends' wills and see what is going on with that, because it's not private. Anybody can do it. And so there are very famous cases with even celebrities who've passed away with just a will. You can look up exactly what they had, where it went, who it went to. Also another fun past activity of hers. But suffice to say, not everybody likes that. Not everybody wants to know what all the hidden inner workings of their family is displayed to anybody who wants to look it up. That's where a trust would come into play. A trust is a private document. There are only 3 people who get to see the full entirety of your trust. The first is you. The second is your attorney. And the third is whoever you appointed as your successor trustee, who would take over for you after you pass away. Your successor trustee doesn't even get to see the entirety of the trust until you've passed away. So really, it's only 2 people during your lifetime. You're welcome to share it with whoever you want. I recommend it. One saying we have in estate planning, to be clear is to be kind. If Billy Job Joe is getting 10% and his sister Betty Lou is getting 90%, that's only going to create a big old headache when you pass away. So maybe at least setting the groundwork that we have a favorite child, whatever that looks like for your family. You do not have to do that. That's just one thing that we generally recommend doing. Trust administration. Trust property can be distributed quickly. It is not costly, it is private, and there is no probate. One caveat to that is a trust is like a bucket. In order for a trust to work properly, we do have to take our assets and put it inside of that bucket. This does not require an attorney to do that. It is just due diligence on you as the individual. Attorneys can do it for you. My firm does it for you. We work with financial advisors to go ahead and transfer any money assets you have into a trust. But we're talking about deeds, cars, boats, RVs. Remember that threshold was $100,000. So anything that could accumulate to more than $100,000, that's what we want to go ahead and put inside of our trust. If, when we pass away, we have assets outside of trust that are more than $100,000, that is where we would have to go through a probate. Every single one of our trust plans gets a backup plan, being a will. We never want to use the will because probate. We do have it there, though, because we do not want the state of Washington deciding where those assets would go if, for whatever reason, we did forget something outside of the trust. So it's there as the backup that we can pour it over back into the trust, but it is not the primary plan because it would force probate. Here is a map. Doesn't really pertain too much to all y'all if we live in Washington State. $100,000. What can you do? For one, we can be proactive. Don't wait to start planning. Even if it's just a basic will, there are resources where we can do a will, even for free online. It will not be the most robust will-based plan you'll ever see in your life, but it is a start. Certain states even allow you to do a handwritten note. Where I live in Idaho, you can do a handwritten, it could be on a napkin, and it would be a legitimate will. The only 3 things that are required for that handwritten will in Idaho is who the person is, what they're getting, and you signed and dated it. And as long as it's got all 3 of those things, that can be a legally binding agreement. Educate yourself. Understand the benefits of a comprehensive estate plan. Getting consultation with whether it be my firm or any firm. Find a firm that is advantageous to you. We do complimentary consultations. I can sit down with you, talk to you about your family, what your goals are, and what a good recommendation would be. And then just not procrastinating. It really does give a good peace of mind. Just being able to know that if something were to happen to me, if I got in a car accident, my wife has the appropriate documents in place that she would be able to make medical decisions on my behalf. If I did pass away, I have the contingency plan of where my assets for my son are going. Because in my young age right now, I don't have a lot of assets, but I do have life insurance. And so that would be a huge payout to my son should that ever be a situation. And I've got it all lined up where he has to work hard in order to get any money out of my trust. But it's all set up the way I wanted it to be. One very critical document that our firm does offer is simply by eLegacy. This is that basic will document that I was referencing earlier. This is not a comprehensive, complete, totally over-the-top estate plan. This is the bare minimum of here's my will, here's what I want to have happen, as well as your healthcare directives, your powers of attorney, and getting that personal property memorandum. Personal property memorandum, I haven't covered this document yet, but think of this as if you were to pick up your house, flip it upside down, and shake it out. If it falls out, it's personal property. If you want that going to one beneficiary or a child or a brother or a sister or whoever it may be, this is where you'd be able to do a handwritten addendum saying, I want my Beanie Baby collection going to my son, Steve. Sign and date that, legal document right there. It is only for assets that are less than $100,000, and it is not firearms. That is one important point I always like to note. There is a very specific trust for firearms called a firearms trust, believe it or not. But besides the point, the basic will plan, that is our pricing. That is what we would be able to do versus our trust pricing down there below, just so everybody has a general idea of kind of what to expect when we start looking at doing our own personal estate plan. Healthy tip number 2, when we have our estate plan, it is wise to review it regularly. People can pass away before you. Believe it or not, it has happened. Assets, agents, distributions change the legal landscape. Washington, you guys have had 2 major estate planning changes within a 12-month time period. Did you know that? If you didn't, you should review your estate plan. It's largely in reference to the estate taxes. Estate taxes, to sum those up easy, just think of those as a death tax. You don't have to sell assets, you don't have to buy assets, but if you meet the criteria of currently being $3 million, if you're north of $3 million and you pass away in Washington, you're getting hit with a 10% tax. And there are ways to mitigate that, if you would like to. I've met 2 clients that did want to pay the estate tax. And I said, by all means, you pay it. Somebody has to. Agents is anybody who has a job. So your trustee, your executor, your powers of attorney, those are all agents, anybody that has a job inside of your estate plan. Distributions being, do you want to equal thirds? Is the house going to one son and the other kids are splitting the brokerage account? Whatever that looks like, making sure that's lined up regularly. And then my personal favorite is family meetings. let's all gather around a table and talk about when I pass away, what's going to happen. But again, to be clear is to be kind in estate planning. Asset titling. I already covered this a little bit, but it is very imperative. If you own real property in the state of Washington, even though we are a community property state, there needs to be very specific language with rights of survivorship on your deed. If there are not rights of survivorship on a deed, then those assets are not transferring to the spouse just like that, easy peasy. There would be a mild form of probate, typically called an affidavit of surviving spouse. Last thing you want to do when you just lost a loved one, especially a spouse, is, hey, let's go to court and get the house figured out. Not something anybody wants to do. So can be very easily avoided if you just check your deed, if you have real property, and it maintains rights of survivorship, or it's titled into a revocable living trust. And same thing with accounts, investments, making sure those are titled properly, either being transferred to your beneficiaries or to your trust. This is one thing we see a lot of. Distributions don't match what your will says versus what your accounts say. That's probably one of the biggest hiccups in any estate planning. And then no named beneficiaries. So again, in Washington, the asset accumulation has to be north of $100,000. Beneficiary designations, transfer on deaths, supersede your estate plan. So if I have an IRA with Tanvir at Heritage Wealth Advisors, and I say when I pass away, I want it going to my wife, and then after my wife, I don't name anybody, and both her and I die in a car accident, that is not automatically assumed that it is going to my trust. It would be under intestacy. Now it's going to the estate of Jake Judd, and now we have to probate that asset. Versus if I had said my wife first and then my trust, there would have been no probate. So that is a very big hiccup we often see as well in estate planning. Children or others have been added to the accounts. This is one thing that I see very often, and I never recommend it, and it's usually for your protection. When we add somebody to our house, when we add somebody to our checking account, savings account, brokerage account, whatever it might be, their liabilities now become our liabilities. If they get in a car accident and get sued, whatever they have, plus whatever you have, is now liable. If they get a divorce and you're there on that account, that can be seen as community property, especially in a state that is community property, like Washington. So that's just the one reason I always recommend it. Obviously, there are extenuating circumstances where we might do it otherwise. Issue spotting for assets. A widowed client selling property as husband and wife, joint tenants in common with no rights of survivorship. This is what I was referencing earlier. For whatever reason, in the state of Washington, our title agencies are not automatically putting rights of survivorship on those deeds. Most commonly, they are doing tenants in common with no rights of survivorship. Deceased spouse's estate still has half a legal interest. What that means is if we had a blended family situation, and so my wife and I have 2 children, if one of my son was mine and our daughter was hers, if when I passed away, half of that house is going to my wife, the other half is going to my estate unless I have it titled properly. What that means is that my wife would own 75% of the house. Potentially, that other 25% is going to my son and not to her. That is the last scenario you ever want to be in, talking with your son about, hey, can you give me the permission to sell my home? That's never a situation I would ever like to see a client in. If less than 3 years have passed since your spouse's death, a probate will likely not be needed to initiate and clear the deceased spouse's interest. It would be a small estate affidavit I referenced earlier. Issue spotting on accounts, adding others to your assets. You could risk the loss of property through divorce, bankruptcy, or lawsuit. Covered that. Might not get to the intended recipients. This is one that I've seen happen very commonly is we have spouse A, or forgive me, child A. So I'll just use my kids' names. My oldest son is Benjamin, my daughter's name is Ada, and then I'll have an imaginary third son named David. In this scenario, where we have 3 beneficiaries, my son Benjamin I listed on the account because I wanted him to help me pay bills and pay my mortgage and whatever it might be. I added him to it because I trust him. However, when I die and I pass away, because he's on that account, it would just go directly to him. And if I kept a lot of cash in that account, there's no legal obligation for him to go ahead and split that 3 ways with his siblings. He can just take the remainder of that. For most clients, they always say, well, my kids would do the right thing. There's a difference between knowing they'll do the right thing and hoping they'll do the right thing. If it's in the trust, they legally have to do it the right way. If it goes directly to them, there's no legal obligation. And would their siblings even know about it? And if that's the case, would they do it? Additionally, for a lot of these assets, if we add a child to them, we lose what's called a step up in basis. Basis is what you acquired an asset for. So I bought a house for $100,000 back in 1990, and today it is valued at $1 million. There has been $900,000 of appreciation over those years. If I were to turn around and sell that, I would get hit with a huge capital gains bill. When we pass assets through death, either through a will or through a trust, they receive a full basis adjustment, meaning that all of that appreciation goes down to 0. So your beneficiaries would pay 0 capital gains tax on any assets that they receive through either a will or a trust. They lose that benefit if you add them on to these asset titlings. So that is one additional reason to not do it that way. Our process. At my team, we offer complimentary consultations. We have a dedicated team of 3. When you meet with us, the first person you're going to meet with is me. I am not the actual attorney you would be working with. My sole job is education, recommendations, talking about estate planning, what would be the right fit for you. The team of 3 that you would be assigned is an attorney that's licensed in Washington, a paralegal who is assisting, and then a client relations coordinator. If you have anybody else you would like to bring into that team, whether it be your CPA, or if you have an existing financial advisor, or if you want to go ahead and now start working with Tanvir, whoever we want to bring in on that team, we're more than happy to do that. Estate planning attorney specialists with the convenience of being remote. You can stay right in your living room and do your full estate plan. Because we are 100% remote, we are 100% virtual, you don't need to go anywhere. We can even send you your documents to remotely e-sign from your house. That's how nice it is. We do have a simple 5-step process. Step 1 is just a simple consultation, having a discussion. Step 2 is a design. This is where we're hammering out the nuts and bolts and details of what your estate plan is going to look like. Step 3 is drafting and review, where we go ahead and actually implement the documents and put them into a very complex legal structure. But then we give you a 5-page plain English summary with a flow chart. I'm a visual guy. I love the flow chart. I was actually just showing a client mine today. I was like, it's kind of complex. Let me just go ahead and show you my picture. Step 4, signing and notarizing. We can do remote online notary. We can do an in-person, send somebody straight to your room. Step 5, the most important step if we are looking at a trust-based plan, is the funding. We do the funding for you, taking the assets out of your name, putting it into trust name. By far, the most common step that is skipped in a trust. If you currently have a trust and you did not do the funding, then your trust is not going to work. Do the funding. The funding is the most important step to any trust-based plan. And again, at eLegacy Law, we do flat rate pricing, and I showed you that screen earlier of exactly what we'd be able to do. So here is my contact information. If you would like to have a phone call, a conversation with me discussing your estate plan, here's my contact information. Feel free to grab a picture of that or write it down. But if not, other than that, that was all I had. I'll turn it over to questions right now. Transfer on death deeds, great question. So what are transfer on death deeds? And I'm assuming you're referring to bank accounts. So TODs, for short, transfer on death, can be used for a multitude of assets. For your checking savings account, you can do that. One caveat that I always say with TODs is, will your bank allow it to be split in multiple directions? If I have 3 kids, will my bank allow me to split it 3 ways? Or, in that scenario I gave earlier, would I have to send it to my son Benjamin and then trust Ben to go ahead and distribute it amongst his siblings? So it is nuanced per the bank. If that's an option you're looking at exploring, I would just ask the questions, is this applicable to me? But yes, TODs, transfer on death, and designated beneficiaries skip probate regardless of the dollar amount. So if you do have those properly titled, then that in and of itself could be potentially your estate plan. But great question. Anything else? Yes?
So if I'm understanding what you just said, my question was kind of a follow-up of that. I've been told that, that I don't need a trust because I have beneficiaries all set up on all of my investments and everything I own, so it won't go to probate.
Yeah.
Correct.
So you're correct, it will not go through probate. My counter argument to that is, if that is the only plan you have, what's the backup plan? People can pass away before me. So when you have a trust or a will, I was just telling Tanvir this earlier today, actually. My plan has 4 possibilities. Option A is, hopefully the way it goes, is it just goes directly to my kids after my wife and I have both passed away. And if they're under the age of 18, I've got very strict rules of how those assets are distributed. Over the age of 18, it loosens up a little bit. And then after the age of 30, they can have a full release. That's my primary plan. Should one of my kids predecease me, or say in the worst case scenario, one of them passes away with me in the car accident, so both my wife, and there's only one remainder, then that's the second backup plan, is everything goes to the one survivor. The third backup plan is, again, never fun topic for me to talk about in my own estate plan, and so I get not everybody likes to talk about it. But third option being is, if something happened to both my kids, where does it go? I have it going down to their children. If nothing, or if they don't have kids and all 4 of us are dead in this scenario, then it would go to people who I have designated, and my church. I have my church listed as a 50% beneficiary in that case, and then my brothers and sisters and sister-in-laws and whoever else we deemed lucky enough to potentially get something. But then we have even another option that's remote contingent. Worst case scenario, where does it go? It's just descendants at large. Anybody who could claim that they're a descendant of me. And again, a lot of really bad things would have had to happen for us to get there. But that's kind of my counter to that, is inside of your estate plan, it can plan for contingencies. If any of my beneficiaries are ever on government benefits, like Medicaid, Medicaid has a recovery that they can make against an estate. So if you're using Medicaid, when you pass away, they'll say, hey, I used X amount of dollars, $500,000 on care during this individual's lifetime, you owe me that money back. Or if your beneficiaries are already on government benefits, it could protect their benefits from being disqualified. Most of these government agencies that we're looking at are income-based. And if they get a large inheritance of $100,000 or up, boom, you're automatically disqualified. If you're living in government housing, you're out on the street until you can find a place you can move into. There's a whole lot of contingencies that just beneficiary designations don't account for. And so that's usually my caveat to that. Great question, though. Yes, sir.
Ballpark, what does it cost to go through the process?
Yeah, so I had a slide popped up earlier. I could probably click back to it here in a minute, but it depends on which one you're looking at. For our will-based plan, if you're an individual, $995. And the question was cost for anybody who didn't hear. But for a basic will plan as an individual, it's $995. For a couple, it's $1,495. Similarly, when we're looking at a trust-based plan, if it's individual, we're looking at $4,250 versus if you're a married couple, $5,250. That does include everything that I've talked about here today. It's the revocable living trust. It is the powers of attorney. It is the healthcare directive. It is the personal property memorandum. It is the coordinated care. It is the deed transfer for a home. All of those topics that I talked about, that's all inclusive. We don't do hourly billing at all. I don't know if anybody's ever worked with an hourly attorney, but you're basically signing a blank check when you do that. I really like our flat rate model of telling you exactly what it's going to cost out the door.
Jake, could you share like an example of a traditional hourly relationship? And if you got questions about how should I set up my beneficiaries, how should I set up my trust, and what that ends up costing versus what's it like with your team?
Yeah, so what Tanvir just asked there is, under an hourly model, what could the cost eventually be? In Seattle, Washington, attorneys are $500 to $700 an hour, and we calculate we would roughly spend 20 to 30 hours per estate plan. So if you're getting charged $500 to $700 an hour, you're looking at upwards $10,000 for the same estate plan that we would do under a flat rate model. Every time you call, even if it's just a 2-minute call, attorneys can only bill in 15-minute increments. So boom, there's $200. You send me an email. How long did it take me to read that email? How long did it take me to reply to that email? Probably half an hour, I'll say. Boom, there's another $300. So the hourly model is, that's why I don't like it, because it feels like now clients don't want to reach out to me with questions because they know they're going to get nickel and dimed for every communication we have. You wave to me when you see me on the street, boom, there's 15 minutes right there. So flat rate model is definitely why we really like that, is because we want to have a collaborative communication. We don't want people feeling like they can't ask us questions. If we're doing a trust, I'm going to give you a Ferrari. I want you to understand how to drive your Ferrari. Yes, miss?
Okay, you're talking to the senior citizens. What can we advise other people outside our kids or friends to use your services?
What advice can you give to use our services?
Yes.
I don't know if I entirely understand the question, but I would say, of when they should look at estate planning? Or the cost?
Anybody can do estate planning, but the question is whether your fees are targeted to senior citizens here versus other people we might refer you to.
No, our firm is, because we're a nationwide firm and we're under the flat rate model, we're smack dab middle for the entire nation of what our cost is. Seattle, it's very expensive. Where I live in Coeur d'Alene, Idaho, not as much. So no, we are not targeted at any one particular audience. We are priced to be competitive. Yes, miss?
You mentioned earlier not to put someone on our checking account. What I was thinking is having my son be put on my checking account as I was on my mother's. When things got down the road, he could pay my bills for me instead of me not being able to do it. You advised against that. What do we do? What can we do in the meantime?
So there's multiple ways you can add somebody to a checking account. It could either be as a joint user or as a co-signer. And again, it's nuanced per institution. Most major institutions do not allow co-signers on checking savings accounts. So they would have to be listed on there as a joint user. Meaning they are on equal status of you on that checking account. So if they went and got in a car accident and got sued, your assets are liable as well. If they get in a divorce, your assets are liable. So to counter that, a power of attorney. That's all they need is a power of attorney that says, yes, I give permission to my son to be able to pay bills on my behalf.
So he doesn't have to be on the account. Just he's the POA as it is now. So
Yeah. If he's already your POA, then that's done and taken care of. You don't need to add him on as your checking account. The only concern now is if something were to happen to you and you pass away, where does that account go? And that's where potentially a transfer on death deed, or forgive me, a payable on death would be beneficial on that checking account, or a trust. But great question so far. Any others? Bueller. All righty. Well, thank you so much for your time today. If there are any questions that you didn't want to ask in front of the general populace, I will be around a little bit afterwards. But thank you, everyone.
Thank you. I'd like to thank these three gentlemen for all the information coming out to Hearthstone, meeting our community, part of the community, but thank you, Jake, for your presentation, Sean and Tanvir. And I'd also like, another Foundation Board member did show here, Mary Brahmins, she's back here. And Marcia Hastings, would you please stand so people can see you as a resident? She is on the board, Foundation Board, and is now a resident here, so you can see her and approach her and Frank and whatnot. But again, thank you so much for attending. Hope you found helpful. Okay, thank you.